Hello, my name is Katie Mercier. I'm the Communications Associate at the Coalition for Juvenile Justice, and welcome to our webinar on exercising judicial leadership to reform the care of youth charged with status offenses. I wanted to run through a couple of technical details before we get started. First, you'll notice that all participants are in listen-only mode, so you will be muted throughout the webinar. If you do have a question, we'll do questions at the end. So at the end of the presentation, you can click the raise your hand button and I will unmute you and you can ask your question. Alternatively, you can also type in your questions throughout the presentation using the questions box, and we will get to those at the end of the presentation. Just a reminder, this webinar is being recorded, and the recording and the PowerPoint will be available on CJJ's website within 24 hours. And with that, I'd like to introduce our speakers today. Chief Judge Kuhn served as a judge in the Family Court of the State of Delaware from 1998 until her appointment to Chief Judge of the Family Court in 2003. Prior to her appointment to Family Court, Chief Judge Kuhn completed a judicial clerkship with the Delaware Supreme Court and practiced in the areas of corporate and commercial litigation and family law from 1989 to 1998. In the area of juvenile justice, she serves as the Vice Chair of the Delaware Criminal Justice Council, co-chair of the Juvenile Justice Collaborative, and serves as a member of the Juvenile Justice Advisory Group and the Juvenile Crime Enforcement Coalition, as well as being on the advisory group for CJJ's Safety, Opportunity, and Success Project. Judge Karen Ashby was appointed to the Denver Juvenile Court in September of 1998 and was appointed as the presiding judge 9 months later, a position that she held until November 2013, when she was appointed to the Colorado Court of Appeals. She is the chair of the Colorado Judiciary's Court Improvement Project and has been a member since 1999. She was also appointed by the Chief Justice to serve as a member of the Commission on Families in the Colorado Courts and the Standing Committee on Family Issues. She has served as a member of the Legislative Task Force concerning the mentally ill involved in the criminal justice system and as chair of the Task Force's Juvenile Subcommittee. And with that, I'd like to turn it over to CJJ's Executive Director, Marie Williams, to begin the presentation.
Great. Thank you, Katie. Good afternoon, everybody. Katie, next slide. So before I start any presentation, I always like to give folks an overview so they know exactly where we're going. But before I get into the substance of what we'll be talking about today, I just wanted to give folks on the phone who don't know the Coalition for Juvenile Justice a little bit of a background on who we are. So CJJ is a national organization comprised primarily of state advisory groups. Those are our core constituents. And state advisory groups are, of course, the bodies that sit at the state level in the executive branch that administer funds appropriated by the federal government under the Juvenile Justice and Delinquency Prevention Act, the JJDPA. And the JJDPA, I think you all know, is the federal law that brings us the 4 core requirements that govern how juveniles are treated in the juvenile justice system. So those core requirements are sight and sound separation, separating juveniles from adults in jails and lockups, jail removal, removing juveniles from adult jails and lockups, deinstitutionalization of status offenders, so keeping status offenders out of jails, and also reduction of disproportionate minority contact with the system. So again, onto the overview of the presentation. I'm going to talk a little bit about the SOS, or the Safety, Opportunity, and Success Project, which spawned CJJ's interest and focus on judicial leadership around status offense reform. And then I'm going to turn it over to Judge Kuhn to talk a little bit about making the case for judicial leadership. Why are judges uniquely positioned to move the needle on status offense reform? And talk a little bit about her experience in Delaware. Then finally, I'm going to turn it over to Judge Ashby, and she'll discuss a little bit about considerations for successful judicial convening. It's often been said that judges are natural conveners, and I happen to believe that they are, but that doesn't always mean that judges and those who seek to have them convene have the necessary tools and skills to put together a successful convening. So Judge Ashby is going to lead us a little bit through that. But before we get to them, I'm going to talk for maybe about 10, no more than 15 minutes about CJJ's interest in this issue. And so with that, Katie, next slide. So why status offense reform? As I mentioned, CJJ primarily concerns itself with protecting the core requirements of the Juvenile Justice and Delinquency Prevention Act. And one of those, as I mentioned before, is the deinstitutionalization of status offenders core requirement. CJJ's had a long-time formal position in, on prohibiting the detention of status offenders. It's something that we've never wavered in, and so believe that it was ripe for a dedicated project around this issue. We also want to advance in practice the policy change that we seek in the reauthorization of the Juvenile Justice and Delinquency Prevention Act. As many of you know, the Act hasn't been reauthorized since 2002. So what we're currently operating under is old law based on old information. And in part to influence the federal government to reauthorize the JJDPA and to influence them to reauthorize it in a way that makes sense, specifically for this population, but also for all juveniles. The SOS project is sort of a ground-up approach to reforming the way that status offenders are treated in the system. And we also want to promote optimal and evidence-based policies and practice. So I talk about the JJDPA as old law because, you know, we now know so much more about young people than we did even in 2002. Recently, the National Academy of Sciences released their report, Reforming Juvenile Justice, and discussed at length the new science we have around adolescent brain development, which establishes definitively that young people, that kids, are different than adults. And it's oftentimes not until the age of 25 that we can expect them to make decisions that are fully thought out and reasoned and mature. So, that's just an example of the kind of thing that's happened in the field that we think ought to be reflected in policy. And, of course, in the policy as it relates to juveniles, the Juvenile Justice and Delinquency Prevention Act. Next slide. So I talked about the DSO core requirement of the JJDPA. It's one of the original core requirements, and it says that young people charged with status offenses, so that's truancy, skipping school, running away, staying out past curfew, being in possession of alcohol, should not be placed in secure detention or correctional facilities. So when the JJDPA originally passed, that was an absolute. However, in 1984, we saw the valid court order exception added to the statute. And the valid court order exception basically says that young people charged with status offenses who violate a valid court order can be held in a secure juvenile facility for a period allowable by state law. Basically, that means if you've got a kid who's habitually truant or who's run away more times than a couple, and who was given an order by a judge to, desist with that behavior, and they don't abide by that order, they then can be confined. That would be the valid court order exception to the DSO core requirement. And we believe that it basically eviscerates the rule. What we now know, this is more new research and science, is that status offenders are among the most likely to quote-unquote reoffend. Their behavior tends to be chronic, repetitive, and indicative usually of deeper issues. Next slide. So how is the nation faring under the valid court order exception? It's used quite a bit in 28 states and territories. They prohibit or choose not to use the VCO exception in practice, and 14, though, have state laws citing prohibitions on use of the VCO. In 2008, 27 of 55 states recorded allowable uses of the VCO exception, as a part of their JJDPA compliance efforts. So a part of the agreement that the states have with the federal government when they take money through the JJDPA is that they have to report on how they're doing complying with the 4 core requirements. As a part of that reporting, they report how many times they've used the valid court order exception to confine juveniles. We do know that some non-VCO states are struggling with JJDPA compliance for lots of reasons, but one is because of minors in possession of alcohol. Next slide. So the valid court order exception was used in approximately 9,850 instances in 27 jurisdictions. And I actually think that that number has gone slightly up. That was the latest data that we had when I first did this presentation a while back, but I think we're now at somewhere over 10,000 uses of the VCO exception. And I say uses of the VCO exception because oftentimes it's reported as 10,000 young people who were confined under the VCO. That's not necessarily the case. So that distinction is important to make. Typically what we've seen around the country is that a few courts or jurisdictions are responsible for VCO-related detention orders. So you can take, for example, a state like Kentucky, which now ranks probably, I think, 4th in the nation in terms of its use of the VCO, meaning they often lock up status offenders for violating a valid court order. But we also find that in Kentucky, there are maybe 1 or 2 jurisdictions that use the VCO in excess and others that use it very little or not at all. Next slide. So, you know, as the science and research has developed and as practices have evolved, we're beginning to see nationwide concern about status offender detention. And a lot of data is coming out showing that the cure might be worse than what ails these kids. Oftentimes we have status offenders placed in units with young people who've committed delinquent or serious criminal offenses. We see them put in confinement with young people who've committed sex offenses. We see them being subjected to programming and interventions that are more appropriate for young people who've committed serious crimes like murder and or rape. And you know, the data is also clear that when we put status offenders in these situations, their reoffense rates increase, their school engagement and success are diminished, which is not surprising, right? Because if you're in juvenile detention, then you're not going to school. And even if there is schooling in a juvenile detention facility, there's also data that shows that it's not at all comparable to what they might get in the community. And further, and not surprisingly, emotional, social, and family problems are also exacerbated when status offenders, or I would posit any kid, is placed in juvenile detention. Next slide. So we're now seeing also that the JJDPA reauthorization push, not just from CJJ, but from many national advocacy organizations, is almost always including a push to improve outcomes for these young people, and to do so by phasing out the use of the VCO exception, prohibiting detention of children under the custody of child protection and child welfare agencies. We see that quite a bit. Placing stricter limits on length of stay if these young people wind up in confinement. And also, because this is something that judges often point to as one of the reasons that they confine status offenders, you know, there's a dearth of services in the community, so they see very few alternatives other than sometimes placing these young people in detention. So the push to reauthorize the JJDPA will include a call for more funds to enrich the continuum of services in the community. Next slide. So the good news is that while we do see the VCO used in excess in some places, national, state, and local trends are beginning to support the institutionalization in general, not just for status offenders. So we see calls all around the country for preventing non-delinquent children from entering locked facilities. We also, though, see, even though it's not on this slide, calls for even delinquent offenders not to be placed in locked facilities unless it's absolutely necessary. There's more of a focus on community-based services than we've ever seen before in the juvenile justice system. And so I won't read everything on the slide, but basically reiterating all the things that I said before, we want to reduce reliance on secure custody, and we want to make sure that services that are available for young people are family and community connected, recognizing, of course, that they will eventually, most of them, return to families and communities. And so we want to have services and interventions that produce the most positive outcomes for youth development and community safety, and also provide the environment where they might thrive once they return to family and community. Next slide. So there is a growing consensus, not only in the field among those of you who've seen and witnessed what confinement can do to young people firsthand, but also on the policy front as well. The Office of Juvenile Justice and Delinquency Prevention supports the elimination of detention for young people charged with status offenses. And twice out of the United States Senate Judiciary Committee, attempts to pass JJDP reauthorization passed out of that committee with a phase-out of the valid court order exception. So there is some support at the federal legislative level for eliminating the VCO as well. And CJJ, of course, because this is what I've been talking about, and the National Council of Juvenile and Family Court Judges, and many, many more organizations than I could possibly list on these slides support eliminating detention for status offenders. Next slide. So just a little bit more about what I touched on before, the dangers of detention. We know that juvenile detention facilities are not ideal places for any young people. But again, the data is beginning to bear this out. We know that these young people will become, or may become, more deeply involved in the juvenile justice system, and many, unfortunately, will graduate to the adult criminal justice system. And that graduation process, sadly, in many states is not a long and arduous one. Obviously, we're still fighting in many states to raise the age, but a 16-year-old in New York State, for instance, is an adult. So that leap from juvenile to criminal justice is not a very, very difficult one. We also know that they're more likely, once they've been detained, to re-enter the criminal justice system, more likely to suffer from physical or mental health problems, more likely to struggle in or not complete school, and to have difficulty in the labor market later in life. Those last four bulleted points, I've had many debates about, chicken or egg. Was it detention that caused these problems, or are they in detention because they have some of these problems? And, it really matters not. I think what the Safety, Opportunity, and Success project stands for is the proposition that either way, detention is not a place where these ills can be cured, and in fact, they will be worsened by detention, especially for young people who have not committed a delinquent offense. Next slide. So a little bit about status offenders. I'll confess that every time I have to use the phrase, it kind of bothers me that we don't have a better way of describing this population, because they are in fact not offenders at all. they've not committed an offense that would be criminal, but for the fact that they're under the age of majority in the state where that behavior occurred. And we know that young people who commit what we call status offenses often deal with really huge challenges in their lives. So they're some of the same kids that you might see in dependency court who've had abuse and neglect in their families. There are kids who've had problems in school, and maybe that's why some of them don't go. They've got undiagnosed disabilities or the effects of past trauma. So they're young people with really complex problems that we believe ought not to be in the juvenile justice system at all, and certainly should not be placed in juvenile detention because of their inability to cope with the chaos in their lives. So what I didn't talk at length about is the Safety, Opportunity, and Success Project strategy of enlisting the support of judicial leaders to deliver this message. I've twice or maybe 3 times spoken to the National Council of Juvenile and Family Court Judges at their conference about status offenders, and oftentimes, you know, the welcome is less than warm, but the welcome gets significantly warmer when I have sitting next to me someone who firsthand can speak to the challenges of being on the bench and wanting to find the best interventions for, you know, what is a really, quite frankly, exasperating population of young people. So I'm going to turn it over to Judge Shanley Kuhn to talk about her experience in Delaware and to illustrate a little bit more what I wasn't able to go into that much, which is, you know, the case for judicial leadership around status offense reform. So with that, Judge Kuhn.
Thank you, Marie. Thank you very much. And we did have a very warm reception the last time we spoke together at the National Council of Juvenile and Family Court Judges. And that is a significant part of our convening power, which is not only convening our colleagues around the nation, but also convening our local colleagues and our other public leaders. So on page 14, we talk about the judicial leadership. And I learned a great deal of what I know from Judge Judith Kaye in New York. She has the power to convene unlike any other judge that I've seen, and she's taught many of us how to do it. And really, we're able to do it because the truth is oftentimes we are public leaders, whether we're elected or appointed. As members of the judiciary, you all have credibility and stature in your arena. And that's the arena where the change is being sought, which is also what's happening in your courtroom. And it can go out into the community. And clearly, we are blessed to have knowledge of the issues that we're trying to address. So specifically on the status offender issue, as we look at status offenders and as they go deeper and deeper into the system, we as judges see that. And one of the ways for us to help reduce that is to take what we know and then turn it around and say, okay, this juvenile, this young, status offender who really started as a status offender has now spent 6 months incarcerated. And we have the knowledge of knowing whether that child's been in child welfare, whether they have mental health issues, and also in the juvenile justice system. And so how do we do that? We work with our key stakeholders, and the key stakeholders are the folks that come into our courtrooms, the other members of the criminal justice system, our attorney generals, our public defenders, our mental health providers. And even now we're beginning in Delaware to work more and more with our schools. I'm actually at a Casey Family Program project where this week working on convening the cooperation between schools and child welfare and juvenile justice. And then finally, when Marie was talking about the labor market, interestingly, we're starting to meet with our Secretary of Labor. Next slide, please. So you all are oftentimes judges, and you're experts in the system. And as experts in the system and being in the roles that we play, we have a vested interest in promoting both sound and efficient policies and practices. Our work is better the more concrete our policies and practices are. Having access to information and individuals who operate within the juvenile justice and related system, I mean, usually that's a fairly easy phone call, email. Even when we don't know the right people, we're able to reach out to folks who can get to those people. And we can help ensure that the goals and proposed outcomes of the process are actually actionable and viable. And sometimes it feels like a whole lot, but if we take it one step at a time, it really does work. Next slide, please. So around the country, judges add legitimacy to the process because really the buck stops at the judicial desk. We are the ones that enter the orders, and so it's obviously important that we are sure to add that legitimacy, but we can assure stakeholders that the time that they're dedicating to our process is not wasted. Then we can issue the orders to compel appearances. I did that often in the beginning of my career, and I found less and less so. Now it's just a matter of speaking with our partners through counsel and in other ways that compelling appearances are no longer needed. So that's a level of success that we've reached in Delaware. And then we're able to get the vital information and data that we will need to inform changes. Obviously, the judiciary, one of our most important roles is that we're neutral. And so long as when we are convening, we convene neutrally, we will be continued to be viewed neutrally. An important piece for me in working on both status offenders and anything in juvenile justice is that I always, whenever the prosecutors in our state, it's the Attorney General's office, is invited to the table, the Public Defender's office is also invited to the table, and vice versa. And so whenever you have or we have competing parties out in the arenas, we make sure that both parties are at the table so that there's no sense that the court is being anything but completely neutral in our convening. And that reach goes well beyond the courtroom. We do meet with legislators. In elected states, I think that may be even easier than others. But there are also, we have access to the people that can meet with the legislators. So that's another big piece. Next slide, please. And the truth is that judges can implement some change. In some circumstances, there are times where we've been able to implement changes in practice. Just yesterday, we were working as our statewide judicial team on whether or not to implement a rule for the representation of all juveniles in the court. And we're working through that process. The Public Defender's Office wants us to implement this rule. And so if the court adopts a rule where every child that comes into our courtroom on a juvenile charge is represented, that's an example of how we can implement change. It doesn't impact anyone other than the juveniles coming into the courtroom, knowing that everybody across the board knows that their cases will not move forward without judicial representation. And then we can encourage parties to consider when changes are needed. And where they're needed. And that's where we typically, so long as we don't just merely stay within our courtrooms, we can have our eyes and our ears to the ground about where we need to make changes. Delaware has 3 counties. Oftentimes, one county will have just a fabulous process, and it hasn't trickled to the other counties. And we get that one county's partners to encourage, another counties. It's not as scary as you think if you change this process, but that can come from very strong judicial leadership in terms of bringing the parties and the agencies together. Once commitments are made, so long as we all are confident that we've made the commitments and that everybody understands what the commitment is, it is up to the judicial branch sometimes to hold people accountable to those commitments. And then there's times where we can raise a public profile of an issue or a problem among our key decision makers. Recently we had a type of case in foster care that was really causing some angst with the different partners at the table. And so what we did was, we went to the foster care team and said, you know what, we think this is happening statewide. Here's some examples of some cases that we've had some concerns with, and we can do it that way. And there are times that convening is a very public thing, but there's also times that convening partners is very private and very quiet, especially when it's a challenging change or something that is a partner really needs to think about what that change means for them. And if we give them the safety and the space to think about how to make that change, we can make it better for them versus having it legislated against them or having some, forceful change. So that's how we've worked through it in Delaware, and I've seen so many other states, and frankly, Marie and CJJ have really helped us think outside the box.
I think
with that, I believe up next is Judge Ashby.
All right, thank you. Well, Judge Kuhn has laid out why judges are in a unique position to convene and the benefits of having judicial officers engage partners in system change. And before I get more deeply into some of the slides, I would just say that I'm a reformed detainer. So there were periods of time when I first went on the bench back in the 1990s that I used detention as well, and it was really an evolution over time where I realized that that was a very poor practice and wanted to make some changes. Sometimes when a judge has the ability to convene, the question then is, when is it appropriate, or why are you going to convene a group of stakeholders to address an issue? Sometimes it may be something internally or something within the court that drives that process, or at other times it may be external. And even though I had begun to question practice within our court of using detention for status offenders, it was really an external event that gave me, I think, the opportunity to really move forward, and that was when our legislature, for financial reasons, capped the number of detention beds across the state that any district had available for use. And at that point in time, certainly I believed that detention was we were going to have to use our detention facilities for those juveniles who posed a risk to the community, and that was our top priority. And so I had that opportunity at that point to really start to engage stakeholders to say, we need to do something different with status offenders. What is it we're going to do? So in terms of going through the slides and the information that's in the guide, I'm not going to go in detail into the guide because I think there's a lot of very positive information that as you read that, you will be able to recognize the structure and the steps that you may need to take to convene and to engage a collaborative process. What I'd like to do is kind of use my successful and not so successful attempts at collaborative efforts over the years and identify and highlight some of the things that are in the guide and that are in the slides. So in terms of assessment and planning, I think one of the important things to do is really ask, why are you going to convene a group of people? What is it you hope to accomplish by gathering a group of stakeholders together? Is there a particular reason why you've decided to act now? Such as in my case, it was external. It may be something else that's driving you to decide to do that. And is the reason that you're seeking to convene people, does that lead you to a particular outcome that you need to accomplish? Is there a particular time frame within which you need to do it? So all of those, I think, are considerations in deciding when and how to even begin a collaborative process. But whatever the impetus may be for you to convene stakeholders, I think it's important to try to clearly define what it is you want to accomplish and why. And the guide, although it's developed to assist judges in leading change efforts, and we would hope that those change efforts may be a reduction, oops, sorry, there goes my phone, a reduction in the use of detention. Ultimately, it can be used by others as well. So it's not limited to judges who want to eliminate the use of detention, although that certainly was one of the purposes initially for the guide. I think it's important in deciding whether you want to convene a group of stakeholders and how you're going to do it also to try and determine what it is you know as opposed to what it is you think you know. And certainly data is one means of being able to do that. You try and look to see what data you have, what does it tell you, what data do you still need, and what can you actually determine from the data that's available to you. Oftentimes, the data isn't going to answer questions for you. It's in fact maybe going to raise more questions that it answers, but it will give you areas of focus as you look towards what the specific issues are that you and the collaborative group may want to address. So I'd also suggest that when you're looking at trying to define what your desired outcome is, it's good to articulate that in a way that each of the stakeholders that may be involved in the process can be engaged in that process and recognize what are the benefits to them in changing the status quo, and why should they care about making a change. For instance, the Department of Human Services in truancy cases may have limited community-based resources to provide to truants, which may lead to decisions to place more children than perhaps the court or others may feel is warranted. But the lack of community-based resources that the department has available may not be a philosophical choice. It may be a choice based upon what actual resources are available to the department. So if you can look to what the stakeholders who you're going to convene, what their stake is, in fact, in the process, that can help you engage them. I would also suggest that when you are looking to describe what the issue is or the outcome is that you want to achieve, rather than looking at it as an agency or individual specific problem, such as the judge uses detention too much and incarcerates too many status offenders, or the Department of Human Services doesn't offer enough services in the community for kids, that instead you look at really the outcome, which is given the number, for instance, given the number of youth that we are detaining, can we identify what is driving that process, and then can we impact those changes? So I would just resist that temptation to identify it as a particular agency problem and instead define it more broadly as what is the specific outcome you want to achieve, and then work backwards from there. Next slide, please. So when we're talking about defining the scope of the process, one challenge sometimes for judges when we look at, are we looking to have an advisory process? Are we looking to get some kind of collaborative consensus out of the process? How are we going to make decisions? Many times the decision-making rule that you will apply is going to be determined by the scope of what you try or what you want to accomplish. Judges, agency heads, others may have limits placed upon them, either ethically or based upon statute or rule, that limit how much decision-making authority they can delegate to others. So when you've identified your outcome, I think you want to then really give yourself a roadmap to know what are the issues ultimately that are impacting that ultimate outcome. What do we need to change, and who needs to be involved in that change process? And I think it's tempting when you have an issue that you've identified, such again, an example may be you want to limit detention of status offenders. I would caution and suggest that you start small to some extent. That may be a good long-term outcome, but I think you also need to start looking at what is it we intend to do long-term, and do we have a committee that's going to look at all of those long-term goals versus a task force that may be necessary in order to implement something immediately or on a shorter term. In my case, for instance, I issued, as a result of the detention cap, an administrative order from the court prohibiting the magistrates in our court, over whom I had authority, from using detention for status offenders. And so that was something where I needed to, other than just issuing that order, I needed to engage the various stakeholders in the process of deciding, well, now what? What are we going to do instead? Who needs to be providing what? And sometimes if you start with things that are process changes as opposed to large, substantive, philosophical changes, that can be a way to get the collaborative process off the ground and to engage the various stakeholders and get them committed to that common goal. I think you also need to be clear as to what decisions are going to be subject to the collective decision-making process and which are not. And as I said, there may be statutes or rules that limit what decisions can be delegated to others. And I think it's clear that even if you do have things that may not be, decisions that you may not be able to delegate to others, that doesn't mean that you still can't engage those stakeholders and use their expertise and use their experience to help inform that decision-making process, even if it's not going to be consensus-based as to a particular issue. Next slide, please. You'll also have to decide when you set up this process, is this going to be something that is going to be a public or a private collaborative process? And within particular jurisdictions, there may be statutes or other guidelines that may drive whether you must or should use a public or private process. And certainly some issues you might need to discuss confidentially and aren't appropriate for public discussion. However, what I would recommend is when you are discussing things that are private, that you've devised a plan to share information to those who are impacted by whatever those private discussions may be, and also to allow them to still have some input as to the issues that you're discussing, and that this should be something that is not information shared at the end of the process, but you should have a mechanism in place by which throughout the process you can keep necessary stakeholders and those who are impacted engaged and educated as to what is happening. So don't wait to include those who are needed to implement change or those who are impacted by the change until after the final decisions are made, even if for some reason there are certain people who may be excluded from that process. One of the challenges also is in many of these collaborative groups, you may have, for instance, from an agency, the agency head as well as individual staff members from the agency. And I think it's helpful for people to all be on the same page in terms of knowing, is it the agency head who has all the authority and is the only one who's able to commit or make certain, commit the agency to certain obligations, or to what extent do the individual staff who are present from that agency have the ability to participate in the process. I think the judge oftentimes is in a position to have those discussions with the agency head to be clear as to who's going to be responsible for what, and to make sure that of the people you have sitting around the table, you do actually have people who have the power to speak on behalf of the agency. Otherwise, it can be a very cumbersome process. Judge Kuhn referenced some of the benefit of having, for instance, a community that is doing very well in a certain area that may relate to the outcome you've decided to address, and having them actually speak to their constituents in an area, for instance, where they're struggling, to help them understand how they made the changes, what the challenges were, what some of the things that they did that worked well, and to actually mentor some of the their constituents through the process. So it's not necessary for everybody to go through that brain damage all over again, and you can use that experience and use that success of other jurisdictions to help move your process forward. Next slide, please. So in terms of implementation, I think one of the key things is oftentimes through this process we get to what we think is an end result. We've identified what the issues are. We think we have all the right people who have been engaged in the process. We've come up with a plan that we think is feasible, and you're ready to roll it out. And so you think, great, we're done. This is our final push. Well, no matter how much time and effort have gone into the planning and development of what you perceive to be your final plan, know that it really isn't final. That as you roll it out, there are going to be those unintended consequences, unanticipated barriers, and other complications, and you'll need to revise the plan. So if you've set up this collaborative process and it's been disbanded somehow after you've come up with your final plan, have some means in place by which you're going to be able to review the implementation of the plan and make adjustments as necessary along the way with the input of all of those initial stakeholders. I think you should not be discouraged by the need to revisit and revise what you've perceived to be your final plan. But just be prepared to know that those things are going to arise and you're going to have to set up some process to address those. And I would also suggest when you're reviewing your plan and the outcomes that you really start looking at things in manageable bits. Don't only, for instance, if your goal is we wanted to reduce the use of detention, look at the number that you end up with to see whether you've accomplished what you set out to be. But in addition to looking at that end result, break down your review of your plan in manageable bits so that you can try and identify if, in fact, you're not achieving your goal, are there particular aspects of your plan or particular points in the process that are the reason for that, so that you can focus your energy on fixing those identified specifics rather than just being focused on, well, we didn't meet our goal, throw the whole thing out, let's start again. If you don't have access to data, which is certainly one of the things that's necessary to track outcomes, because I think it's very important for us not to just feel good about what we're doing, but to have some measurable means of knowing whether the changes you've implemented have made a difference. There are some other things that you can do. If you don't have the means, whether financial or otherwise, to access data which will give you some of the information that you need, think about some other ways, such as user surveys, where you might be able to gather some of that information and ultimately be able to look as you're implementing your plan to know what things are, what parts of your implementation plan and what parts of the process may be problematic, where you're having successes, and be able to build upon those or be able to mitigate whatever those challenges may be. I guess the last thing I would say is you do not have to go it alone. For those of us who went on the bench and perhaps were not anticipating at that point that you were going to be leading collaborative processes and system change in a broader sense. There are many who have already gone through this and can share their experience, lessons learned, as well as things that were very helpful to do along the way. And both CJJ, National Council, and others are certainly willing to provide resources, and there will be stakeholders from within your type of agency or role who can speak directly to what some of those challenges may be from your own perspectives. Are others still on the line?
Sorry about that. I want to thank both of the judges for speaking today. At this point, we'll take questions. Like I said, you can type in your question in the questions box or use the raise your hand feature on raise your hand button, excuse me. If you are on a cell phone, we strongly encourage you to type in your question. I will say, while people are getting a chance to do that, that both the guide that Judge Ashby referred to is the Convenor Action Guide, and it is available on CJJ's website, but I will also put it up there with the recording of this webinar. And so I'll give everyone a minute to type in their questions. Okay, our first question, and we had a number of people ask about parental involvement, is what role can or have parents played in a convening?
This is Judge Kuhn. I think parental involvement and youth involvement is a critical piece because these are laws and rules and the implementation of policies, especially with status offenses and any other offense, but these are offenses that don't rise to the criminal level that involve these students, and oftentimes they are not deep into the system. And so their involvement in telling us as decision makers and as collaborators what they want to see and what works best is an important piece. I think Colorado has done an incredible job with that through both some community activism and some collaboration. So maybe Judge Ashby has some more.
I agree with Judge Kuhn that it's essential to have the youth and parent perspective. Obviously, there are challenges in how you do that and who you choose. We have had in various collaborative efforts that we've done over the years both youth and parent involvement. Some of that has worked more successfully than others. But usually what we found is obviously you don't want to get a youth or parent who may be currently involved in the system because of, or at least in the court with whom they're participating, because that can create some ethical problems. But the Department of Human Services, whether at your state or local level, oftentimes will have youth advisory boards or other access to youth who are very interested in engaging in system change efforts. They also can provide resources to help support the parents and youth being engaged. Obviously, for those of us in the system, especially juvenile systems, it seems, meetings is what we often do when we're not on the bench. And as far as being paid and those kinds of things, it's not an issue. For parents and youth, it may be difficult for them to break away from their school or work obligations, and the departments can oftentimes provide support not only in identifying who would be good participants, but also providing some resources to support their engagement. So I agree that it's essential to have the youth and parents involved, and there have been a number of departments, for instance, across Colorado, who have parent mentors, who are those who have been involved in various parts of the system, who are mentoring parents who are currently involved, and we've found that engaging them in many of these collaborative processes has been a real benefit.
I would underscore that. This is Marie from CJJ, that the involvement of young people and families is essential, and I think Judge Ashby had it exactly right, that oftentimes, especially with these processes that involve folks that are intimately involved with and know about the juvenile justice system, that families and young people can be hamstrung by their comparative lack of information. So engaging them is essential, but also building their capacity so that they can meaningfully engage is essential as well.
Our next question is, what specific approaches have you found to keep children charged with status offenses out of detention?
In Delaware, we started applying our law appropriately. We have a law, 10 Delaware Code Section 1007, which identifies when youth are to be detained and when they are not, and we were illegally detaining. And we first worked very hard with our JP court to look at where they were detaining kids and where our family court was detaining kids. We looked at our own data and we looked in-house. And then we modified the statute so that it was more consistent with our practices that we're developing, which is trying to keep youth out. The other effective tool, which is not, the states that are using it are kind of already set, which is the Juvenile Detention Alternative Initiative, and that's truly where Delaware got started. And our pre-adjudication detention rates have gone down by 2/3 in the last 6 to 7 years.
One of the strategies that we used in Denver some time ago, which I think helped to a large degree because it provided a lot more information to, and this was in the truancy context, the example I'm giving, it provided a lot of information to the court and the court participants once the case hit the court, was requiring attached to any truancy petition a detailed outline from the school identifying what efforts had been made by the school, what engagement they had had with the youth and the family, if they were aware of what efforts were used and why those failed, include that information. It was just a very simple thing initially, just realizing that we weren't always effectively sharing information so that the court participants could be sufficiently aware of what the barriers may have been to success, and we were having less frustration perhaps by the judges in trying to address the truancy behavior. Frankly, one of the things that I did that I think helped people take a harder look at what they were doing with status offenders, I was on the National Council Board when we initially voted to support the reauthorization of OJJDPs without the valid court order exception. That did not go over well when I shared that, frankly, with a number of my colleagues here in Colorado. But what I did, which I think helped us internally within our own court as well as across the state, was really to be transparent about what we were doing and about what success we were having and what the challenges were, and then offer up assistance to those jurisdictions who were having some challenges. So we shared information very openly and publicly about what the detention numbers were, where we were having the most numbers, what the valid court order violations were district by district, and then for those districts who were struggling, we offered support to them. And some of those supports really were, in some jurisdictions, they didn't have access to some of the services that they thought were necessary to avoid detention. And we were able to, through various departments of human services and school districts, start sharing the information as to how various districts across the state had been able to address those issues.
And I would also encourage folks to look at the reforms that happened recently in Georgia and in Kentucky, where there's a really specific pathway that has to be followed before kids can be referred to the juvenile justice system. I think in both those states that was primarily a response to high numbers of school-based referrals to juvenile justice that folks thought were better dealt with in the school sphere. So I would urge folks to look at those two states and the work that they've done on that issue.
This is Judge Ashby again, and I would just make one last comment, which I think oftentimes judges themselves and then others have sometimes viewed the court as the ultimate hammer, and really that there wasn't as great a role for them to play in diverting kids from the system. And I think one of the things that was important for me was to continue to make the statement that we could be a support to the community, and we could be a support to the school districts and to others who are wrestling with this problem, even if they weren't actually filing petitions with the court, that they didn't have to wait to engage the court in those hoped for changes and looking at strategies to divert cases from the court without involving the court, that we weren't just limiting ourselves to those cases where petitions were filed, but we had as much of a vested interest in what cases were not coming to the court as we did in cases that came to the court.
Okay, I believe that's all the time that we have. I want to thank our presenters today for doing this webinar. As I said, the Convenor Action Guide, the PowerPoint, and the recording of this webinar will be posted on CJJ's website within 24 hours. And with that, thank you everyone for joining us, and have a great weekend.
Thank you very much.
Thank you.